Good morning, and for some of you, good afternoon. My name is Sarah Reynolds, and I'm an International Arbitration Associate at Mayer Brown, and I'm honored to moderate today's webinar. Joining me today are Jim Ferguson, who is a partner at Mayer Brown. He focuses his practice on intellectual property, complex commercial litigation, and domestic and international arbitration. We also have Steve Anderson. He's Vice President in charge of Mexico, Canada, and the United States at the International Center for Dispute Resolution. Before we begin, just a few housekeeping announcements. First, as we go along, we hope that you'll ask questions by using the Q&A panel on the right side of your screen. We'll make every effort to answer questions towards the end of the webinar. If we're unable to answer your questions during the presentation, we'll follow up with you directly after the webinar has ended. Second, regarding CLE credit, we'll be providing an alphanumeric code during the presentation. In order to receive CLE credit, participants must record this code on the virtual sign-in sheet that was emailed to you with the login instructions for today's program. With these two housekeeping points aside, let's get started. A number of arbitration institutions have issued revised rules in recent years. For example, the ICDR, the American Arbitration Association's International Arbitration Arm, and the LCIA, the London Court of International Arbitration, issued new rules in 2014, as did the ICC, the International Chamber of Commerce, earlier in 2012. So we thought it pertinent to spend some time comparing these various sets of rules. In particular, we'd like to focus on provisions related to emergency relief, consolidation, expedited proceedings, discovery limits, party disclosures, duties, and award deadlines. We plan to conclude with a discussion of how these rule changes might influence the drafting of arbitration clauses. Starting with you, Steve, are there any general trends that you think are worth noting from this recent series of changes?
Sure. First, I want to thank Sarah and Jim and Mayer Brown for the opportunity to participate in this program. I've been looking forward to it, and so thank you. Let me go over, you'll see from this chart here that in this last series of changes, there have been a variety of rule changes that were really not part of the international arbitration or even in many ways domestic rule set prior to that. And you can see that through the points that Sarah has just highlighted that many of these points have been considered. It's also worth noting kind of the time frame that some of these rule changes are needed. If you look at some of these, 12 to 14 years with some of the institutions that have taken in their last change. For the ICDR, it took about 8 years from the last major rule change. There were some others along the way. So I think it takes a little bit of time for the rule changes to occur, and there's other trends and otherwise to keep an eye on. One other point here that's not noted is arbitrator availability, for example, and all the major institutions have included and added, rule mechanisms that really say arbitrators have to be available to serve. And so that's, they say them slightly differently, and all these rules also have slight variations that you might want to pay attention to. You'll notice down at the bottom of the page here that interim, which was revised in 2010, is really based upon an ad hoc system of arbitration. In other words, these rules are built so that if parties want to use them without an institution, they can. You'll see that there's no emergency interim relief mechanism and no consolidation mechanism. They do have a joinder mechanism if that can happen early enough in the process. But as these things evolve, big parties and companies and otherwise need to be aware if they're incorporating, these rules which are philosophically aligned with ours but without an institutional arm, don't have some of these resources available to them. And we'll talk about some of these along the way, obviously, but I think it's worth noting that you need to be aware of of some of the, what I would call gaps in using trial rules without an administering institution. Even with an administering institution, you're going to have some difficulties if you want those two provisions, for example. let me just jump into this slide as well, just to kind of give you a feel historically as to the cases that are filed on an annual basis with these institutions. You'll see in the last few years we've surpassed 1,000 international case filings. We're very excited about this. It's a lot of work to just make sure that people are aware of the ICDR as the international division of the American Arbitration Association. It's been about 10 years since we changed the name and really separated those divisions with different rules, different arbitrators, different administrators and offices, and so on and so forth. So you can also see here that the ICC's caseload has also been very strong over the years historically, and mediations as well. And just to give you a reference point, the AAA domestic caseload surpasses all these by leaps and bounds, but yeah, you can get a feel. The LCIA caseload is probably about half of the ICC's historically in terms of year-in, year-out caseload activity. I don't know if you have any comments here, Jim or Sarah, but that kind of gives you just a feel as to what's going on.
Thanks, Steve. Sticking with you and moving on to the topic of emergency interim relief, how do the revised ICDR rules address emergency relief?
So I think it's helpful to kind of start at where this came from. And back in 2006, we created this rule set. It was Article 37 at the time. It's now Article 6. And the idea was we wanted to provide parties a different option if they needed emergency interim relief. The rules currently provided for then the parties' option to go to court, a local court jurisdiction, or they could wait for the regular arbitral tribunal to be appointed. That could take, depending upon the case and the size and dynamics, up to 30 to 60 days or more, depending upon what was going on. And if you weren't able to wait for that period of time, you could have needed to go to a local court, and maybe you weren't comfortable with that either. So we built this rule mechanism really as an opt-out mechanism. In other words, it was built into the rules. And when we first built this rule, there was a provision that required a contract after May 1, 2006. And that was the idea back then, is we want to make sure they are at least aware of it, but after that time, any contracts would have access to this rule. And you can see the time frames here are really efficient. A day to appoint the arbitrator, a day for a challenge, a couple of days to get things scheduled here. So we built this, and to be honest, we had some criticism and some public naysayers that were saying you're crazy, and let's see if it can work. And believe it or not, it has. We've had over 50 cases with this since that period of time, and the cycle time of these cases is about 3 weeks from start to finish. And the arbitrators have almost always been appointed within the 1 business day, as far as I know. And so, really, a great story here. I've heard anecdotally some great stories of, issues and cases where they just wouldn't have been able to do anything at all to resolve this within a court of the local country or the seat of the arbitration. And so, a good success in terms of the interim relief. Now, the only thing that we did to update this in this last rule change was we took out the date requirement, which we felt that this is really kind of the standard. Most every arbitral institution in the world has adopted a similar provision to this, and so we didn't feel the date was necessary, and we moved the rule mechanism from the last rule up towards the beginning of the rule set, because these obviously apply early in the proceedings. And so those are kind of the highlights of this rule and where it started and where it is today.
Great. Jim, can you talk about other institutions and whether or how they provide emergency relief?
Thanks, Sarah. As you see on this slide, and as Steve mentioned, virtually all of the major international arbitral administering institutions have adopted provisions governing emergency arbitration proceedings. On this slide, we highlight 2, the London Court of International Arbitration and the ICC. At the bottom of the slide, you can see that as part of its 2014 amendments, the LCIA in Article 9 established a procedure for the expedited formation of a tribunal and for the appointment of an emergency arbitrator. Similarly, the ICC in Article 29 and in Appendix 5 lays out procedures for the appointment of an emergency arbitrator when measures are claimed to be necessary that cannot await the constitution of an arbitral tribunal. And in the ICC's Appendix 5, the ICC has laid out some fairly detailed rules governing the appointment of an emergency arbitrator, challenges to the emergency arbitrator, and the scope of the authority of an emergency arbitrator. Significantly, both in the ICC and the LCI provisions, the decisions of the emergency arbitrator are not binding on the tribunal, so the tribunal, when it's eventually constituted, can revisit, modify, or vacate decisions by the emergency arbitrator. It's also worth noting that under all of these provisions, the administering institutions affirm the ability of the parties to apply to any competent judicial authority for interim relief. That's important because one weakness of international arbitration, at least in terms of interim relief, is that the administering bodies do not have the authority of the state to enforce an interim measure. So that, in a nutshell, describes the provisions of the other institutions in emergency relief.
Thanks, Jim. Switching topics now.
Sarah, can we go back to, let's go to 9 really quick. Just one quick point on here. I think it's worth noting. You'll notice there's some actually, sorry, going back up to emergency, sorry, the slide, 7th slide. There we go. Within the form of decision, there's some flexibility here between order and award that I think is worth noting for the parties, and for I think the ICC only allows an order. So you know, in certain jurisdictions that might be pivotal. And there's also an issue here where on costs. In some institutions, you might have to pay more administrative fees in order to do this, and so just to keep your eye on those factors as you move through. All right. Go ahead, Sarah. Sorry.
Oh, thanks, Steve. Switching topics now, traditionally concepts like consolidation and joinder were sort of difficult to square in international arbitrations and domestic arbitrations really as well. What has the ICDR done with its revised rules to provide for consolidation?
Sure. This was probably one of the most debated articles in the rule change that we just did in 14, and we had advisory committee members from around the world in different jurisdictions, civil and common law, and we wanted to provide this mechanism, and we went back and forth, and I guess one philosophical point that is worth noting is the ICDR adheres to a philosophy that is really buys upon to arbitrator authority is greater than institutional authority. And what I mean by that is that when everything is said and done, we want arbitrators making key decisions during the administrative process. And that's as soon as we can get them involved along the way and throughout and towards the end as well with the award. And going to consolidation here, there was first there was a debate that the consolidation issue should be decided by the institution. And we went back and forth. Then we came back to kind of a hybrid of that, which allowed for the institution to decide, or maybe an arbitrator, either or, depending upon the parties. And in the end, we came back to really what we buy onto is to appointing a consolidation arbitrator to handle these difficult decisions, and appointed for that special purpose. Very similar to the emergency arbitrator, the time frames are a little bit different. So that is the kind of the purpose and the start of the consolidation arbitrator, and what we were looking to do when we built that process.
Interesting. Jim, do other institutions provide for consolidation?
On this slide, Sarah, we're looking at not only the ICDR, but also the ICC and the London Court of International Arbitration provisions governing consolidation. It may be useful to identify 3 scenarios in which consolidation can occur under both the ICDR and the ICC provisions. The first is the situation in which the parties agree to the consolidation. The second situation arises when claims are made under the same arbitration agreement. And then the third scenario arises when the arbitrations have the same legal relationship or transaction and the same parties. So again, under scenario 1, the parties agree. In scenario 2, the claims arise from the same arbitration agreement. And in scenario number 3, you have the same parties, the same legal relationship or transaction, and compatible arbitration agreements. Now, someone may ask, what does compatible arbitration agreements mean? That means that, as a practical matter at least, there has to be some common elements. They have to have the same governing law, same administering institution, the same language, the same situs of arbitration, because if there are any differences in any of these key elements, then consolidation as a practical matter would not be workable. The LTIA provision is a little different because it limits consolidation to 2 scenarios. The first, of course, is where the parties agree in writing, and the second is where multiple arbitrations have been commenced between the same parties and involving the same or compatible arbitration agreements. So under LCIA, unlike ICDR or ICC, the consolidation mechanism is limited to situations involving the same parties.
So you're pointing to a clear trend then among arbitral institutions to allow for consolidations at least under certain circumstances. Jim, I'd be curious to hear from you about the practical impacts on parties now that consolidation options exist more clearly in international arbitration.
So I think consolidation options have become more attractive, particularly to sophisticated practitioners in certain industries. Energy and construction come to mind, where parties are involved in a single project or a single transaction, but enter into contractual relationships with multiple other parties. To take a kind of classic simple example, in a international construction contract, one party may enter into subcontracts with several other parties. And even though they're separate agreements, the relationship between the agreements is such that it would really promote efficiency and reduce the risk of inconsistent results if there was a consolidation. And I wouldn't be surprised in the future if we see the consolidation trend expanding to include other industries where there are agreements with multiple parties, particularly in large projects or transactions.
Moving on now to expedited proceedings. Steve, the ICDR's 2014 rules are unique among its peers because those rules include articles related to expedited proceedings. Can you walk us through how that works?
Absolutely. And so the idea here was really, our domestic counterpart, the AAA, had for a while, expedited rules and the construction division as well, and we really wanted to provide something on the international level that provided for some real efficient arbitral processes. And so we built these sets of rules, and there's some philosophical points I think that are worth noting here. The time frames as you move through here are fairly set, and sure, there's an ability to get some extensions and request that from the parties and the institution as well. But from start to finish, the process is essentially 135 days. and you can, from start to finish. I think one of the other key points to note is when we talk about detailed submissions, the first box there, it was really based upon a civil law philosophy, and let me tell you a little bit of a background to that. I have been with the organization for over 20 years, and in my early days, I used to administer, commercial domestic arbitrations, and we would get arbitration notices that would come in the door, and they would have the parties' names and their representatives, and then under the description of the case, it would say, describe the case, and there would be 3 words: breach of contract. And that was the full scope of what was requested or described, and that was often very difficult to give the arbitrators, once appointed, a feeling as to the dispute that was going on. To the opposite point, in my travels to other countries, in Mexico, for example, often filed there within the court system is any and all evidence and documents included, to the extent that it's papers and papers and binders of information submitted. Very much a civil law philosophy. And so when we created these rules, we really built them on a civil law philosophy, and we asked parties to include all evidence and materials at that point to start the process. And we feel that kicks things off much more efficiently than breach of contract, 3 words. Now they can, if the attorney's used to those 3 words, we give them a little time to cure that, but it's just a good example of a system and rules that really will move economically for disputes that are below $250,000 by presumption, and companies are actually coming to us and asking if they can include clauses for $5 million and below, if you will. So that's a highlight on what we're trying to do and what these rules do.
Great. And the ICDRs, these expedited proceedings, have been available now for about 2 years. Has the ICDR gained any insights on when this works well or when it really adds value? Yeah,
the parties got to be ready to participate, and one of the debates we had on this is, the arbitrators likewise have to. We ask early and if you will thoroughly to make sure the arbitrators are available to serve and can handle these things within the time frame needed by the parties. And so those are some of the checks and balances. And we historically have had early administrative conference calls on all of our cases. And so that's really the opportunity for us to kind of dig in and make sure we're all on the same page and everybody's understanding what the rules mean and how they work. And so those are some lessons. Different industries might be a little more flexible with this, and others, sophistication probably helps here. If they know the process, they can do it a little more efficiently, right?
Great. And Jim, what advantages can you point to that expedited proceedings might provide for parties?
As Steve noted, under the ICDR's expedited proceedings provisions, the streamlined procedures available for cases that are below $250,000. And so this provides as close to a guarantee as one can get that in smaller cases, the parties are going to get a quicker and therefore a far more cost-effective resolution. This has always been touted as an advantage of arbitration in general and international arbitration in particular, but in recent history, those advantages have tended to be eroded by real-world practice. So this is a great option for parties having smaller disputes who want to contain the cost and guarantee a very timely resolution.
Interesting. And Jim, you just made the point that we're seeing costs and life cycles expand in arbitration. A lot of that has to do with discovery and the expanding role of discovery in arbitration. So I'd like to talk about, switch to that topic if we could. The ICDR also uniquely includes discovery limits in its revised rules. And Steve, I'd love to hear from you about what the rules have to say on document production.
That's great. So this was another example of some rule changes we did along the way. In 2006, we created the emergency interim relief mechanism, and in 2008, we created guidelines for document exchange, and the marketplace was clamoring for a more efficient process. And we put together an advisory committee to really help us with this. And the idea was, what can we do to keep some of the integrity with international arbitration? And so we built some rule mechanisms here that you can see from this chart. We, in 14, essentially almost adopted this rule sent right into the rules, very little changing, a few words here and there maybe, but essentially gave us some ideas. I want to kind of go through what I think are some of the key points in that idea. Is we hear and have heard that, U.S.-style discovery is not beneficial towards the efficiency of the arbitration process. And at the same time, there's advocates who are comfortable with that and want to do that, and so on and so forth. We felt on the international side of things that we needed to make a benchmark as to what was appropriate. If parties want to agree otherwise, they can, and the rules clearly provide for that. So we incorporated a document exchange standard of relevant material to the outcome of the case, which is similar to the IBA rules. That request is not only for international, for paper documents, but also electronic documents. And so we've got a great standard here that where parties can rely upon that standard and ask for documents specifically, and not ask for a company's whole computer drive or otherwise that could take a lot of time and money. So a good standard to start with. I also think that we included a mechanism in this rule that basically says U.S.-style discovery is not appropriate for international arbitration under these rules. And parties can agree otherwise. It doesn't say there'll be no depositions or interrogatories or otherwise, but it does say they're generally not appropriate, and so it really sets a nice benchmark for economy and efficiency. Now, there's going to be some who might not agree with that. We've actually had a number of U.S. companies who want to get back to the basics have come to me and say, Steve, can I include these rules in my domestic contracts? And believe it or not, we've had companies that have done that. So that's the idea. Getting back to the basics of economy and efficiency is what was done here. Just a quick point on the privilege, Article 22. This is a standard that is really unique to any sort of rule out there in terms of what's available, and it provides a standard that the parties will be treated equally to the highest level of protection. So nice, another rule mechanism that's available.
And have you seen that the rules have helped sort of stem the tide of U.S.-style discovery and arbitration?
Yeah, I've heard.
Agree.
Yes, sorry, go ahead, Sarah. I'm sorry.
Or in the alternative, are parties agreeing to additional discovery to get around these limits that are included in the ICDR's rules?
I think they're probably by and large, I'm hearing that parties love this rule, and they come to me and they say, Steve, I was in a hearing, and one of the parties was asking for X number of depositions, and I pulled out this rule, and it was great. And then there's obviously the exception where the party says, I needed this and I wanted this, and they were able to do it as well. So I think it sets, more than anything, just a really good benchmark as to what we're trying to do in terms of economy and efficiency in the process. And there's no other rule set in the world that does this, as far as I know. I've never seen anything like it. So it's domestically, internationally, it's really nice. So.
What's the role of the Arbitration Tribunal Authority here in terms of helping to reach these goals of efficiency?
I'm sorry, can you restate that?
What's the role of the Arbitration Tribunal?
Okay, so it's really total discretion here in terms of their authority, and that's why who you pick as arbitrators is really important, and how they manage it. So if there's disputes or disagreements on this, they're going to be the decision makers, and so it's key to bring them in and have them involved in issues as they arise.
Great. And Jim, from a client's perspective, how does the client benefit from the ICDR's discovery standards?
So I think the ICDR rules on discovery and document exchange codify what many have traditionally viewed as the prevailing practice in international arbitration, in which depositions, for example, are discouraged. Document production is generally limited to specifically identified documents. But there are 2 points I want to stress about that. First, these decisions are often left to the discretion of the tribunal. And in these disputes, one party or the other will typically be clamoring for more discovery. Second, the discovery issues, of course, could also be addressed by the parties in their agreement. But the difficulty is that when you're drafting an arbitration provision for a standard contract, for example, and everything is sweetness and light with the opposing party, it's difficult, if not impossible, to foresee which party is going to benefit from more discovery or even less discovery. So the advantage that the ICDR offers is that it codifies into a rule what has been widely accepted as the standard practice in international arbitration. And it also prevents costly disputes about discovery and privileges before the tribunal. Just the codifying the privilege law that will govern, for example, is a huge plus, because otherwise you are likely to see disputes about what law should govern privilege claims that are made in international arbitration. So this is a plus in terms of promoting the efficiency of the dispute resolution process.
We just received a question from the audience that's relevant to this topic. Steve, in advance of depositions, or in the absence of depositions and interrogatories, are witness statements required ahead of any live testimony?
Great question. This is really often the presumption of the international arbitration practice, and so so yes, that's a common practice, and many and probably a majority of the arbitrators really go by that philosophy and approach. Now, there might be exceptions, and there might be variations to that, certainly, but that would be a good presumption. I saw a multi-million-dollar case administered within just a week with witness statements, and they only did cross-questioning of a few of the witnesses after they'd all submitted witness statements. It was amazing to see how efficient that process was. So.
I agree. Witness statements are the favored practice in international arbitration. Among other things, they allow the tribunal to more fully prepare for the hearing, because they will have had the opportunity to read the witness statements in advance of the hearing, and as a result, the live testimony will essentially focus on cross-examination, all of which saves time.
Right. Moving on now to party disclosure rules, the LTIA, the ICC, and the ICDR all have similar party disclosure rules. Steve, can you walk us through the ICDR's rules and explain sort of what they're for and when those disclosure obligations are triggered?
Sure, and I think generally speaking, you know, within a 15 to a 30 day period, you know, parties can challenge an arbitrator after they hear information or are given disclosures and so on and so forth. And so there's a fairly standard practice to that, and you know, the independence and impartiality of the arbitrators is critical to the outcome of the case, and all the institutions take this very seriously. And so that's the benchmark to start with. I think a couple of the points that are worth noting in terms of ICDR that are a little unique, and then you see here in 13.5, we added a duty to the party. We added two party duties, and this is one of them in the new rule versions. that really says, you know, if you know something about the arbitrator, a relationship or a circumstance or whatever it might be, you've got to disclose that within a reasonable period of time, or you're going to lose your right to challenge the arbitrator. And we heard enough anecdotal stories where, you know, Google searches or otherwise, people were able to get information and hold it in their back pocket till the award came out in either in their favor or not, and so on and so forth. Now, some of that was just obviously stories of you know, you hear at conferences or otherwise, but you know, I think there was some legitimate concern in some practice areas for this, and so we really wanted to put a duty on the parties to make sure they knew they had to participate actively in the process, and it just wasn't the arbitrators and the institution, you know, going through the disclosure. So that's again a real big highlight as to a unique mechanism here for party disclosure.
And so when does a party waive their right to challenge an arbitrator? What are the circumstances where you'd have a waiver?
Yeah, I think if there's a relationship that they know about, that they don't, and you know, if the arbitrator knew about it, would clearly disclose it, and you know, they wait until the morning of the hearing or otherwise or afterwards. You know, there's all sorts, and relationships are hard. Philosophically, we ask all of our arbitrators to disclose, and it's a high benchmark, really, compared to some of the other practices around the world. It just is, and some of the arbitrators don't like it. But to the point for us is we would rather know a little more than we need to know, just in case. Put it on the table, and then we'll keep or remove arbitrators as appropriate. And so, in this circumstance, we want the parties to have that duty here. And if there's clearly information that comes up where there's a challenge later in the process, that then we're going to make that analysis and decide whether they had the right to challenge or not. So.
And has the ICDR done any analytics on how often arbitrator challenges occur, on how often they're successful?
We do have, on average over the past few years, you see we have about 1,000 cases. It's been fairly flat, 60 to, let's say around 60 cases per year. We have 60 challenges per year. And some of those cases we've had multiple challenges, believe it or not. But, so 60, 65, 70 challenges, not all are removed. We're really cautious about protecting the integrity of the process, because challenges have crept up over the past, what I would say, 5 or 6 or 7 years, and so not all challenges are going to remove an arbitrator, and I think we think that's important, because sometimes we try to appoint the best arbitrator we can in the first instance, and so we go through the process, and whether it's ranking or the list or otherwise, but we really work hard to get the appointment right. So we look at every challenge very seriously and analyze it. And
when there is an arbitrator challenge sort of later in the game that's justified for whatever reason, how does the ICDR handle that? If it's, let's say the hearing's already started or even concluded, and then there's a successful, legitimate arbitrator challenge, what happens then?
Let me give you an example of it wasn't necessarily a one where one was removed, but we had a hearing down in Florida, and we had a hearing scheduled for Monday morning, and it just so happened, I think the morning of, there was a challenge of an arbitrator that came up, and we quickly the tribunal dismissed the parties for the morning. We went and worked with the parties and went through. One of the things we don't do is we get the disclosures from the arbitrators, but we don't tell the arbitrators who's challenging, and we try to keep a level of discretion so we're not poisoning the punch of the arbitrators, if you will, and so there's no animosity or implied concerns there with the disclosure. So as much as we can, we we separate that. And then in this case, later that afternoon, the parties were back at the arbitration process because we had maintained the arbitrator. Now there are times where arbitrators have to be removed, and in that scenario, we would have to go back to the drawing board and probably do some rescheduling, right?
Mm-hmm. And Jim, when can parties consider making an arbitrator challenge?
Let me answer that question, Sarah, by first talking about the LCIA and the ICC provisions governing arbitrator challenges, which are very similar. Under the LCIA provision, the party must challenge the arbitrator within 15 days of the formation of the tribunal or within 15 days of becoming aware of the factual basis for the challenge. Similarly, the ICC in Article 14 provides that the party must challenge within 30 days of the appointment or 30 days of the receipt of facts and circumstances for the basis for the challenge, and then the ICC court will decide the challenge after giving the arbitrator and all parties an opportunity to respond. So my own view of arbitrator challenges is that they should be made extremely judiciously, that is only in cases where you have a very compelling argument, and if you become aware of facts after the period within which the challenge must be made, the facts, in my view, cannot be publicly available. In other words, if Steve mentioned a Google search, if you learn through a Google search 15 days or 30 days after the appointment, in my view, it's not going to be worth making that challenge. So I don't favor challenges to arbitrators except in circumstances where you have a very compelling case.
Agreed. So moving on then to the next topic, one complaint that I hear sometimes and indeed have experienced myself is that sometimes in international arbitration, arbitrators take quite a long time to render their awards. So you have discovery standards and discovery limits in place, and you've hurried through your hearing and expedited proceedings, and then often there's a long wait at the end there until the arbitrator, the tribunal, speaks. Steve, what has the ICDR done to prevent delay with awards?
Let me start with some information that's not on this slide. We've went and recruited and found arbitrators like Jim and others around the world. We have around 750 plus arbitrators around the world that we really look at carefully. Every year we review that group. We add to it. Others are, we have applicants each year, and we rotate people off that list as well. We require they all take a training program to understand case management issues, and these are sophisticated professionals. We've had some of the world's best, and well-known arbitrators take our program and come out raving of the program and the things that they enjoyed and learned from the activity. So it's really crucial. You can get to the process here, but the arbitrators and who you have are of critical importance. Let me go into some of the rule mechanisms that I think are worth noting here. The award is really a key duty of the tribunal, and we want them working on it as quickly as possible. We put a new sentence in this rule set. It's the second sentence down. The tribunal shall make every effort to deliberate and prepare the award as quickly as possible after the hearing. So that's a duty of the tribunal. We have, you'll see down below, 60 days from the closing of the hearings. That time moves really quickly. We've historically been able to do that. A lot of our rules or international cases come in under the AAA commercial rules, which have a 30-day deadline. So we've done that consistently and haven't really had problems with that. And so 60 days is very reasonable, but at the same time, we really have to make sure that the arbitrators are deliberating as soon as possible, and they're starting to prepare that award quickly. We recommend in our training programs that they schedule a couple days right after the hearing and sit down and start deliberating and working on it. So those are a few issues, some time frames and some training that really make a difference.
And Jim, have other institutions implemented similar rules?
As we see on the slide, that the ICC has, in Article 30, set forth an ideal, maybe aspirational goal in the eyes of some, of 6 months. That period can be fairly easily extended by the tribunal or by the agreement of the parties, obviously. And the LCIA has an even more elastic standard of as soon as reasonably possible. So these are not hard and fast deadlines, obviously, and I think they reflect a couple of realities that the parties have to balance when they often justifiably complain about the length of time. The first is the unanticipated complexities of the case, and the second is the schedules of the arbitrators, because most parties want sophisticated professional arbitrators deciding their cases, and sometimes their schedules will not allow them to draft the award in 6 months if the case is more complex than anticipated. So I think my impression is that all of the institutions are sensitive to this issue, and my sense is that they use sort of back channel methods of trying to convince, encourage, or pressure their tribunals to issue the awards as quickly as possible. And if multiple extensions are requested, my impression is that encouragement and or pressure increases.
Sarah, just a quick point here. I think you'll notice here that an extension here is really not allowed unilaterally by the tribunal in our rules. We made that change in specific. Nothing wrong with the tribunal, but we wanted either the parties or the institution to make that extension. I think that was a good point, Jim. And you know, it gets hard. I mean, people get busy in schedules, and so sometimes you really have to kind of hold them to the deadline and the time frames to do that. So.
Well, and it's an interesting point because it's difficult for the parties to do that. I know in my experience, in not calling out any particular institution, at the end of the arbitration, the arbitrator almost always says, you know, the rule says I have to have the award issued by X, you know, X amount of time. Can I take longer than that? And the parties certainly aren't going to tell the decision maker no. And so it's helpful to have, you know, working back channels to move things along.
If that was us, Sarah, will you tell me afterwards? Because I mean, hopefully, and that's okay. But I think that's, you know, parties shouldn't be in a situation where they are beholden to the tribunal, and that's a hard, you know, position to be in. So, agreed.
And our final topic then is to look at how these various rule changes impact parties when they're drafting and negotiating arbitration clauses. Do you want to walk us through the checklist you put together on that point?
Yeah, and just we can walk through some of these points here, and Jim, we can jump through this, you know, together. I just some points here. I think scope of the arbitral disputes, I think, is really important. One of the issues for us is international or domestic. Is the question that a lot of companies don't ask. I meet with corporate counsel all over the place, and they're often not distinguishing their arbitration clauses with that criteria. And I think it's important. I mean, there's a different, you have the treaty for the New York Convention enforceability, you have some other rules now. So I think it's an important question in terms of how are we starting out, where are these applying, and so on and so forth. Jim, do you want to go through some of these as well? I don't want to, if you have any comments, I don't want to interrupt the flow here. When we keep going, have other thoughts, or?
So I think we want to leave at least some time for questions. Let me just make a couple of general statements, Steve, and then you can add comments. I am a litigator, and an advocate, and so as well as a neutral. So I encounter the provisions of the arbitration agreements when it's too late to do anything about them. And as a result, my mantra to my clients is, this is something that you need to pay attention to in drafting your agreements. We've all heard that before, but let me make a couple of suggestions. The first step is to understand the options that are available to you. We've talked about recent amendments that several of the major institutions have made. It's critically important that you recognize those amendments and understand that these are tools that are available to you when you're drafting your arbitration clause. We talked about, for example, compatible agreements. If you're in the construction industry or the energy industry, you're going to be involved in single projects with multiple parties. You may want to draft your standard contract in a way to ensure compatibility so that you would at least have the option of consolidation later on. The selection of arbitrators, I can't stress how important that is, the method of selecting the arbitrators. Just simple points like, do you want arbitrators to come from common law or civil law jurisdiction? That is a critical difference. And finally, do you want party-appointed arbitrators? Do you want institutional-appointed arbitrators? Again, a critical difference, and some of these can literally be outcome determinative.
That's great. So let me just go to the next couple of slides, and then I think that'll kind of cover a couple of points. This is our standard clause. I would use standard clauses with institutions. They're there for a reason. They're simple. Don't get too creative on us, please. The problems we have administratively are when people get really creative and you know, that creativity is great in other forms, but not necessarily in international arbitration clause drafting. 3 points, you know, arbitrators, place of arbitration, language, consider these points. They also make things more efficient. Once you go to the next slide, this is a clause that it's getting more and more traction. One of the things we've heard is people want to do mediation, but they don't want to be beholden to a condition precedent or a step clause or otherwise. And this is what we call a concurrent arbitration mediation clause. And you can start the arbitration and the mediation kicks in automatically. Just a different option for people in the marketplace. So those are some thoughts on drafting. Otherwise, just let me go to the last slide, and we'll have a few minutes for questions. These are the people I work with around the world. We have offices in Singapore. Michael Lee's in Singapore. He handles cases there for us in Asia, and we have offices in Houston and Miami administering cases as well, in New York and Seoul and Bahrain. So anyways, that gets you a feel across the world of what we're trying to do.
Thanks, Steve. And we do have one question from the audience, going back to arbitrator challenges. Are there tactical reasons for challenging arbitrators? I ask because I suspect a good arbitrator would either decline to serve or withdraw if he or she could not properly serve.
Jim, I don't know if you want.
I'll take the first cut at that. One thing I've noticed is that there's a tension between, on the one hand, an independent and impartial arbitrator as kind of an aspirational goal, and on the other hand, the requirement the parties typically include in their agreements of someone with substantial background and experience in a particular industry, a particular field of law, a particular sector of technology. If you're going to require arbitrators who have a specialized background, you're going to increase the likelihood that the arbitrator knows other people, other companies, other institutions in that same area, and this may later give you cause for concern. And I think that you have to recognize and expect that there are going to be those kinds of relationships among arbitrators when you require the arbitrators to have a specialized background. Now, I'm not sure I agree with the questioner that a good arbitrator would either decline to serve or withdraw if he or she could not properly serve, because the reaction of many neutrals to a challenge is likely to be that this alleged relationship in no way compromises my ability to be fair and impartial in this case, and he or she may therefore have an instinct to to defend himself or herself against the allegation. And the risk, of course, is that that will be the reaction, and the further risk is that it will, as Steve mentioned earlier, poison the arbitrator if he or she is aware of who made the challenge. And in many cases, no secret about who made the challenge, particularly in situations involving party-appointed arbitrators that are challenged by the other side.
I'll agree with you, Jim, on all those points. I think there was a time where arbitrators were probably recalcitrant to stay on board if they were challenged. But I think those days of, and that was a long time ago, I think by and large arbitrators are willing to maintain the integrity of the process because they see challenges coming up strategically, like was mentioned in the question, as opposed to, really factually or substantially. And so I agree with what you're saying. And by and large, I think most would stay on, and unless there's a realm of uncertainty, then they might preclude themselves, right?
Correct.
We had one other question come in. What about allowing an appeal to a second tribunal as a protective measure against a rogue decision in light of Hall Street? AAA now allows it, and I've included it in my arbitration provision since developing it with some of your Mayor Brown colleagues in 1999.
Sure. We have the optional appellate arbitration rules available. Let me just say, generally speaking, this was not created for the international marketplace. This was a set of optional rules really based upon a domestic U.S. philosophy of appeal and otherwise. And so with that in mind, I understand there's been at least one or more international cases where it has been used. The issues on appeal are very limited: error in law that is material and prejudicial, or determinations of fact that are clearly erroneous. And so those are what you have to overcome. And if parties want to incorporate that by agreement, they can do it, and we've built a mechanism to do that. I don't know if, Jim, you have any other comments on that?
Just briefly, I'm a big fan of the appellate procedure because it provides a check against what is widely viewed as one of the weaknesses of arbitration, and that is the risk of an arbitrary, capricious, or rogue decision. And so I encourage clients to give serious consideration to that option, although it's an option that must be considered on an industry-by-industry and business-by-business basis.
And I would analyze. I agree with you, Jim. I think there's a place for it, in certain realms. I think the tension for me is subject matter expertise versus appeal, and in the judicial system, we're not really getting judges or juries with subject matter expertise, and so that's the balance. If you're comfortable, and if you're really comfortable with the ability of the arbitrators and their subject expertise, then maybe you're less inclined to do this sort of appeal. But otherwise, anyway, that's just an interesting way to think about it for me.
Well, thanks, Steve. As mentioned, if you've submitted a question that was not answered, we'll follow up with you directly. Should you have any additional questions related to today's topics, please email them to Anne Leger at ALEGER@mayorbrown.com. If you're interested in learning more about the ICDR or Mayor Brown's international arbitration practice, please visit the websites linked to your screen. Thanks to our panelists, Jim and Steve, for all of their insights, and thanks to all of you for listening.